in the state of Florida versus Nicholas Cruz, case number 18-1958, CF10A. The defendant is present. Would all parties present please... What was that? I don't know. What was that noise? I'm sorry?
We lost microphone on that. We lost microphone.
So what do I need to do? Oh, the whole thing has to reboot? Should I wait? I announce for the record, would both sides please announce their names for the record?
Elise McNeil on behalf of Nicholas Cruz.
David Wheeler on behalf of Nicholas Cruz.
Michael Satz on behalf of the state of Florida.
Jeff Marcus on behalf of the state of Florida.
Carolyn McCann on behalf of the state of Florida.
Okay, we're here for the defendant's change of plea. I have the plea form, I have the score sheet, the rights waiver, and as far as I'm concerned, we're ready to go. Ms. McNeil?
We're ready to proceed, Your Honor.
Okay, do you want to bring your client to the podium, or do you want him to have him stand there?
Whatever you
I think it
prefer,
would be
Your Honor.
easier if he comes to the podium.
There's some additional attachments to the plea
I
form.
saw, thank you
Okay.
very much. Okay, Mr. Cruz, we did this on Friday. We're going to do this again with regard to case number 181958. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Please state your full name for the record.
Nicholas Cruz?
Now, I know you answered these questions on Friday, but I have to ask you again. Are you currently under the influence of any alcohol or illegal drugs?
No, ma'am.
Do you take any medication, or have you started taking any medication since Friday?
No, ma'am.
And you said that you have been perhaps informally diagnosed with depression and anxiety. Did you think of anything else since Friday?
No.
Okay. And are either of those issues disturbing you in any way today?
Yes.
So the depression and anxiety are bothering you today?
Not the depression, just a little anxiety.
Okay. A little anxiety is normal under the circumstances. What I need to know is, are you able to understand me and listen to me when I'm speaking to you?
Yes, ma'am.
And are you able to follow along with your lawyers when they speak to you?
Yes, ma'am.
Are you having any trouble concentrating?
No.
And other than being nervous or anxious, are you having any difficulty understanding anything that's going on here today?
No, I understand what's going on.
Okay. And sir, please, how old are you?
I am 23 years old.
And again, how far did you get in school?
I think 11th grade.
And you do read and write the English language?
Yes, ma'am.
Have you gone over the plea form with your lawyer or
Yes.
lawyers?
Yes, I have, ma'am.
Okay, and did you, I'm going to just go ahead and have you pass this to one of you, please. Yes. And Mr. Cruz, if you would please take a look at this document and let me know if that's the document that you went over with your lawyers, including the addendums, which list counts 18 through 34, along with their minimum and maximum penalty, as well as their minimum mandatories under Florida's 1020 life statute.
Yes, ma'am.
And those are your signatures and your initials?
Yes, they are.
Okay, and did you go over each and every one of those pages with your lawyer or with your lawyers, plural?
Yes, I have.
And did your lawyers explain each and every charge to you, as well as the maximum penalty under Florida's 1020 life statute for the attempted murder counts?
Yes, ma'am.
Okay?
Can we just have 1 second, Judge?
Absolutely. Yes, thank you. Okay, sir, you have been charged by indictment with 34 counts, and I'm going to go over those counts with you now. Counts 1 through 17 of the indictment charge you with murder in the first degree. These are life felonies. They are punishable, they're capital felonies, and they are punishable by one of two ways, either life in prison or the death penalty. Do you understand?
Yes, ma'am.
Do you understand that in Florida, life in prison does not carry parole like other states?
I understand.
Do you understand that life in prison means the term of your life? It means you will not come out until you are no longer alive. Do you understand?
Yes, ma'am.
And have you gone over that with your lawyers?
I have.
And do you understand that that is the minimum penalty on counts 1 through 17? In other words, that is the best case scenario for you as a term of the rest of your life in Florida State Prison. Do you understand?
Yes, ma'am.
And do you understand the maximum penalty is death?
Yes, ma'am.
Do you understand that that issue will be left to a jury to decide in a separate trial.
Yes, I do understand.
Do you understand, has anyone made you any promises or guarantees as to what sentence would be imposed if you were to plead to the charges 1 through 17 of murder in the first degree?
No, ma'am.
And when I ask you if anyone's made you any promises or guarantees, I mean your own lawyers as well. Have they made you any promises or guarantees as to what sentence would be imposed, whether it be life or death on counts 1 through 17 by you pleading here today?
No, ma'am.
Now, sir, this is what we would refer to as a strategy decision. In other words, by waiving your right to a jury trial on counts 1 through 17 specifically, you're waiving your right to require that the state prove each and every one of these charges against you beyond and to the exclusion of a reasonable doubt. Do you understand?
I understand.
And do you understand that if the state were unable to prove any of the elements in any of counts 1 through 17, the jury would have to find you not guilty? Do you understand?
I understand.
Do you understand a possibility could be that a jury would find you guilty of a lesser included offense to any of these charges, which may not include a mandatory life sentence at a minimum? Do you understand?
Yes, ma'am.
Do you understand that by pleading to these charges, you are facing a minimum best case scenario of life in prison?
Yes, ma'am.
And have you discussed this strategy with your lawyers?
Yes, I have.
And do you believe that it is in your best interest to enter into a plea to these charges and waive your right to go to trial and require the state to prove these charges against you beyond and to the exclusion of a reasonable doubt?
Yes, ma'am.
And have you gone over the pros and cons of that decision with your lawyers?
Yes, I have.
And have you had enough time to consider both the pros and the cons of your decision?
I have.
Ultimately, it is your decision, and whatever decision you make is fine with me. I'm not here to tell you what decision to make. I'm here to make sure that whatever decision it is that you make is made knowingly, voluntarily, and intelligently, so that you are fully informed and you understand the consequences of your decision. Have you gone over the consequences of this plea here today of guilty with your lawyers?
Yes, ma'am.
And do you understand that you are waiving your right to have the first part of the trial, which is often referred to as the guilt phase, where the jury would find you guilty or not guilty?
I understand.
And do you understand that the state will still have the opportunity to present testimony and evidence against you at what's called phase 2, or the penalty phase of the trial?
Yes, I do understand.
Okay, and you've gone over that with your lawyers in depth, is that correct?
Yes.
Do you have any questions about your decision?
Yes.
You do have a question?
I was wondering if I could say something to the victims.
Okay, well, before you do that, do you have any questions about the rights that you're waiving, or about the decision that you're making, or the strategy decision that you're making with your lawyers as far as pleading today?
No, I understand.
Okay, and you fully had the chance to think about that and to discuss that with your attorneys, is that correct?
Yes, ma'am.
Has anyone threatened or coerced you into entering into this plea today?
No, ma'am.
And sir, have you had ample time or enough time to speak to your lawyers about your plea?
Yes.
And is there anything else you feel your lawyers need to do on your behalf that they have not already done before you enter into your plea today?
No, ma'am.
Sir, do you understand, I've gone over charges 1 through 17. I've told you that they carry a minimum of life in prison and a maximum of the death penalty. Counts 18 through 34 you're charged by indictment with attempted murder in the first degree, and each of those carries a separate penalty, so I'm going to go over those with you now. With regard to count 18, attempted murder in the first degree concerning victim Ashley Baez, you're facing up to a 25-year minimum mandatory prison sentence because the state has alleged that you actually possessed a firearm, that you discharged that firearm, and as a result of said discharge, you inflicted great bodily harm upon Ashley Baez. Do you understand, sir?
Yes, I do.
Do you understand that you're facing between 25 years to life in prison as a maximum penalty?
Yes, ma'am.
And do you understand that the 25-year minimum mandatory prison sentence is a day-for-day sentence under Florida's 1020 life statute?
Yes, ma'am.
Count 19, you're charged with attempted murder in the first degree with regard to victim William Olson. Sir, in that particular charge, the state has alleged that you discharged a firearm, that you possessed a firearm, which means it carries a 20-year minimum mandatory prison sentence under Florida's 1020 life statute, up to and including life in prison. Do you understand?
Yes, ma'am.
Count 20, attempted murder in the first degree with regard to victim Kashava Managapuram. The state is alleging in that count that you discharged a firearm, and as a result of the discharge that you inflicted great bodily harm upon this victim, which carries a 25-year minimum mandatory prison sentence under Florida's 1020 life statute up to and including life in prison. Do you understand?
I understand.
Count 21, attempted murder in the first degree of Justin Colton. That is a 20-year minimum mandatory under Florida's 1020 life statute for the use and possession and discharge of a firearm. Do you understand?
Yes, ma'am.
Count 22 is attempted murder in the first degree regarding victim Alexander Dorette. The state is alleging in that count that you did actually possess, use, and discharge a firearm which carries a 20-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
I understand now.
Count 23 is the attempted murder in the first degree of Genesis Valentine. The state is alleging that you actually possessed and discharged a firearm which carries a 20-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
I understand.
Count 24, the attempted murder of Daniela Menescal. The state is alleging that you actually possessed and discharged a firearm under Florida's 1020 life statute, which carries a 20-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
Count 25 is the attempted murder in the first degree of Samantha Grady. The state is alleging that you did actually possess and discharge a firearm when you attempted to murder Samantha Grady, which carries with it a 20-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
Yes, ma'am.
Sir, count 26 is the attempted murder in the first degree of Samantha Fuentes. In that count, the state is alleging that at the time you did possess, discharge, and inflict great bodily harm upon Samantha Fuentes, which carries with it a 25-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
Yes, ma'am.
Count 27 is the attempted murder in the first degree of Isabel Checker. The state is alleging that you did possess and discharge a firearm contrary to Florida's 1020 life statute, which imposes a 20-year day-for-day minimum mandatory prison sentence. Do you understand?
Yes, ma'am.
Sir, count 28 is the attempted murder in the first degree of Samantha Mayer. The state is alleging that you did actually possess, use, discharge, and as a result of the discharge, inflict great bodily harm upon Samantha Mayer, contrary to Florida's 1020 life statute, which carries with it on that count a 25-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand, sir?
Yes, ma'am.
Count 29, attempted murder in the first degree of Benjamin Wickender. The state is alleging that at the time that you attempted to murder Benjamin Wickender, that you did discharge the firearm and inflict great bodily harm upon Benjamin Wickender, contrary to Florida's 1020 life statute, which in this count carries with it a 25-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand, sir?
Yes, ma'am.
Count 30, the attempted murder of Madeline Wilford. The state is alleging that in this particular count you did possess, use, and discharge a firearm inflicting great bodily harm upon Madeline Wilford, contrary to Florida's 1020 life statute, which carries on this count a 25-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
Count 31 is the attempted murder in the first degree of Marian Kabachenko. The state is alleging that in this particular charge that you did possess and use and shoot a firearm during the commission of this charge, and that you discharged a firearm, contrary to Florida's 1020 life statute, which carries with it a 20-year minimum mandatory prison sentence. Do you understand?
Yes, ma'am.
Count 32 is the attempted murder in the first degree of Stacy Lepel. In this count, the state is alleging that you discharged a firearm during the commission of the felony, which carries with it a 20-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
Count 33 is the attempted murder in the first degree of Anthony Borges. The state is alleging on this charge that you did actually possess, use, discharge, and as a result of the discharge that you did inflict great bodily harm upon Anthony Borges, contrary to Florida's 1020 life statute, which carries with it a 25-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
And finally, in count 34 of the indictment, the state is alleging that you attempted to murder in the first degree Kyle Lamont, and that during that act you did actually possess, discharge, and inflict great bodily harm upon the victim, contrary to Florida's 1020 life statute, which carries with it a 25-year minimum mandatory prison sentence, which is a day-for-day sentence under Florida's 1020 life statute. Do you understand, sir? Sir, do you understand that on counts 1 through 34, by entering into a plea, you are giving up your constitutional right to require that the state prove each and every one of these allegations beyond and to the exclusion of a reasonable doubt?
Yes, ma'am.
Do you understand you're giving up your right to present testimony and evidence or a defense, if you have one, with regard to these charges?
Yes, ma'am.
Do you understand that at trial, sir, your lawyers would have the opportunity to confront and cross-examine each and every one of the state's witnesses who's called to testify against you?
Yes, ma'am.
Do you understand, sir, that at trial you would have the right to remain silent, and that's an absolute right that could not be and would not be held against you in any way whatsoever? However, by entering into a plea to these charges, you are giving up that right. Do you understand?
Yes, ma'am.
Sir, do you understand that you are giving up your right to appeal the judgment and sentence of the court? In other words, if you were to go to trial and you were to be convicted on any of counts 1 through 34, or a lesser included offense of counts 1 through 34, and your lawyers, or you or an appellate lawyer, believe that error was made during the course of the trial, you would be able to appeal the judgment and sentence to a higher court. That's a court that sits in appellate capacity above this court. Do you understand?
Yes, ma'am.
Do you understand, sir, that by entering into a plea, you're waiving that right?
Yes, ma'am.
Do you understand, sir, that if you are found, if you are sentenced to death in this case, that will not be a reason to revisit the strategy here today? In other words, the decision that you and your lawyers have made to plead guilty to these charges, which carry a maximum penalty of death.
Yes, ma'am.
Do you understand that if you're on death row waiting to be sentenced, you can't say, you know what, that wasn't a good strategy. Maybe I should have gone to trial and required the state to prove it. It will be too late at that time. Do you understand?
I understand.
Do you understand that after today, when I accept your plea, you are stuck with your decision and you cannot change it? It will be too late.
I understand.
Do you understand that if you tell your lawyers, you know, put this back on the judge's docket because I changed my mind and I want my phase 1 of the trial, you will not be able to change your mind. You will not be able to make that decision after today. Do you understand?
I do understand.
Do you understand that there have been a number of appellate issues that have gone on throughout the course of this case? Do you understand by entering into a plea you will be waiving your right to appeal those issues to a higher court?
I do understand.
And are you comfortable with the decision that you have made today?
Yes.
Do you feel you've had enough time to speak to your lawyers and to decide whether or not this plea to phase 1 of the guilt phase is in your best interest?
Yes.
And do you believe that decision to be in your best interest?
Yes, ma'am.
Do you have any doubts about that?
No.
Do you need additional time to speak to your lawyers about anything that I've gone over or about your decision to plead guilty to these charges here today?
No, ma'am.
Sir, do you understand all of the constitutional rights that I've gone over with you?
I do.
And do you understand that you're waiving each and every one of these constitutional rights?
I do.
Do you have any questions about any of these rights?
No, ma'am.
Do you wish to waive these rights and enter into a plea today?
Yes.
Sir, do you understand that if you are not a U.S. citizen, you will be subject to deportation under the laws and regulations of the Department of Homeland Security upon entering into this plea?
Yes, ma'am.
Do you understand, sir, that if the offense to which you are pleading is determined to be sexually violent or sexually motivated in any way, or if you've been previously convicted of a sexually violent or sexually motivated offense, this plea may subject you to involuntary commitment under the Jimmy Rice Jessica Lunsford Acts upon completion of your sentence? Do you understand?
I do understand.
State, have you disclosed all items of physical evidence in discovery?
Yes, Your Honor. I must say that, discovery is still going on
Sure.
for the defense and the state as we go, and it has been, since the beginning of this case.
Okay. To this point, has the defense reviewed all of the discovery in this case with your client?
Yes, Your Honor.
And is either side aware of any physical evidence, if tested, that would exonerate the defendant of any of the 34 charges as charged in the indictment?
The state is not aware of any.
Your Honor, based on the discovery that we have received, we are not aware of any.
Okay, thank you. Okay, does either side believe that there is anything that I need to go over with the defendant that I have not already gone over as far as his plea is concerned? State?
Yes, Your Honor.
Okay?
Just to clarify, counts 18 through 34, the maximum sentence for, the court clearly went over the minimum mandatories, that each of those counts carries a maximum sentence of life imprisonment.
Okay, sir, do you understand? I'm sorry if I did not make this clear. Counts 18 through 34, attempted murder in the first degree, carry the minimum mandatory penalties that I went over with you, which were either 20 or 25 years. That's a day-for-day prison sentence under Florida's 1020 life statute. However, they each, in and of themselves, without the 1020 life enhancement, they still carry life in prison. Do you understand?
I do understand.
Okay, Mr. Marcus?
Your Honor, as a result of pleading guilty to these charges, have any promises been made to the defendant by anyone as to what evidence will be admitted or excluded from the penalty phase?
Sir, have any promises been made to you as far as what evidence may or may be presented against you by the state at the penalty phase in this trial?
No, ma'am.
Okay, do you understand that you should, as far as you're concerned, you should go forward with the understanding that everything that could be presented against you can, I'm not saying that it will be or that it is, but you should assume that all of the evidence that was going to be presented against you will be presented against you in phase 2 of the trial, with the exception of any constitutionally excluded evidence, which I don't believe, well, some of the orders that have been signed to this point where that both parties have agreed that a certain evidence would be excluded, that would still be excluded, and perhaps any other constitutionally impermissible evidence that hasn't been decided on yet. But under the rules of evidence, anything else that would be admissible will be admissible for purposes of your understanding this plea going forward at the phase 2. Do you understand?
Yes, ma'am, I do.
Has anyone made you any promises or guarantees that certain evidence would be excluded during phase 2 that may be admitted during phase 1?
No, ma'am.
And do you understand what I mean when I say phase 1 and phase 2?
Yes, I understand.
You've gone over those phases with the lawyers, and I've explained it to you. Phase 1 is what we typically call the guilt phase, where the jury would find you guilty or not guilty, or perhaps guilty of a lesser included offense. And phase 2 will be life in prison, meaning life with no parole. There's no parole in Florida, you understand?
I understand.
Do you understand that in a lot of states, life means life, but in 25 years, they'll consider you for release? Do you understand?
understand.
But Florida, we do not have that. Life means you are in there for the term of your life, and you do not come out until you are no longer alive. Do you understand?
I understand.
Okay, Mr. Marcus?
One more, Your Honor.
Sure.
And that is, does he understand that all of the attempted murder convictions can be used as an aggravating factor in each of the 17 first-degree murders that will be heard before this jury, and that each of the murders will be an aggravating factor for each murder? In other words, for each murder, there would be 16 additional murders as an aggravating factor and 17 attempted murders.
Okay. So, sir, based upon the state's notice of intent to seek the death penalty, first of all, have you gone over that with your lawyers?
Yes, I have.
And there's actually there's 2 drafts. The second draft, which I believe is the most updated draft, was filed on April 16th of 2018, and it is 3 pages and lists 7 different grounds or aggravators that the state intends to go forth on during the penalty phase. Do you understand?
I do understand.
And do you understand that the felonies that you are pleading to, in other words, I'm going to give you an example. Count 1 of the indictment charges murder in the first degree of Luke Hoyer. By pleading guilty to count 1, the state can use count 1 as an aggravating factor for count 2, murder in the first degree of Martin Duque and Keanu. Do you understand?
Yes, ma'am.
And so forth and so on. And in other words, each count that you are pleading to can be used as an aggravating factor to argue in favor of the death penalty on each of the other counts of murder in the first degree. Do you understand?
I do understand.
And do you understand, sir, that counts 18 through 34, attempted murder in the first degree, can all be used against you as aggravating factors in support of the death penalty on counts 1, 2, 3, 4, through and including 17, individually and collectively? Do you understand?
I do.
Mr. Marcus?
That's all, Your Honor.
Okay. Ms. McNeil, do you have anything that you feel I have not gone over, which I should go over with the defendant at this time?
No, Your Honor.
Okay. Mr. Cruz, at this time, do you have any questions?
Yes.
Other than the fact that I believe you want to make a statement, but do you have any questions about the rights that we've gone over, about the penalty phase versus the guilt phase, about any of the specific charges against you, any of the minimum penalties, any of the maximum penalties? Do you have any questions whatsoever about those things?
No, ma'am.
Okay. And is your client waiving a pre-sentence investigation?
Yes, Your Honor.
Can't be waived. So I have to order it. And if the defense doesn't want one?
If it's statutorily required, Judge, at this point, we'll say yes, and if there's any issues, then we'll notify the court.
Okay, that sounds good. Thank you. Okay, Mr. Cruz, I'm going to go over each charge with you and ask you how you wish to plea in these matters now, if you don't have any questions.
I do not have any questions.
All right, to count 1 of the indictment, murder in the first degree of victim Luke Hoyer, how do you wish to plead?
Guilty.
To count 2 of the indictment, murder in the first degree of Martin Duque Anchiano, how do you wish to plead?
Guilty.
Count 3 of the indictment, murder in the first degree of Gina Montalto, how do you wish to plead?
Guilty.
Count 4 of the indictment, murder in the first degree of Alexander Schachter, how do you wish to plead?
Guilty.
Count 5 of the information, murder in the first degree of Elena Petty, how do you wish to plead?
Guilty.
Count 6 of the indictment, murder in the first degree of Alyssa Al-Hadef, how do you wish to plead?
Guilty.
Count 7 of the indictment, the murder in the first degree of Nicholas Dorette, how do you wish to plead?
Guilty.
Count 8, murder in the first degree of Helena Ramsey, how do you wish to plead?
Guilty.
Count 9, murder in the first degree of Christopher Hickson, how do you wish to plead?
Guilty.
Count 10, murder in the first degree of Carmen Shentrup, how do you wish to plead?
Guilty.
Count 11, murder in the first degree of Aaron Feiss, how do you wish to plead?
Guilty.
Count 12, murder in the first degree of Scott Beagle, how do you wish to plead?
Guilty.
Count 13, murder in the first degree of Meadow Pollock, how do you wish to plead?
Guilty.
Count 14, murder in the first degree of Kara Loughran, how do you wish to plead?
Guilty.
Count 15, murder in the first degree of Joaquin Oliver Pudoy, how do you wish to plead?
Guilty.
Count 16, murder in the first degree of Jamie Gutenberg, how do you wish to plead?
Guilty.
Count 17, murder in the first degree of Peter Wang, how do you wish to plead?
Guilty.
Count 18, attempted murder in the first degree of Ashley Baez, how do you wish to plead?
Guilty.
Count 19, attempted murder in the first degree of William Olson, how do you wish to plead?
Guilty.
Count 20, attempted murder in the first degree of Kashava Managapuram, how do you wish to plead?
Guilty.
Count 21, attempted murder in the first degree of Justin Colton, how do you wish to plead?
Guilty.
Count 22, attempted murder in the first degree of Alexander Dworet, how do you wish to plead?
Guilty.
Count 23, attempted murder in the first degree of Genesis Valentine, how do you wish to plead?
Guilty.
Count 24, attempted murder in the first degree of Daniela Menescal, how do you wish to plead?
Guilty.
Count 25, attempted murder in the first degree of Samantha Grady, how do you wish to plead?
Guilty.
Count 26, attempted murder in the first degree of Samantha Fuentes. How do you wish to plead?
Guilty.
Count 27, attempted murder in the first degree of Isabel Checker. How do you wish to plead?
Guilty.
Count 28, attempted murder in the first degree of Samantha Mayer. How do you wish to plead?
Guilty.
Count 29, attempted murder in the first degree of Benjamin Wickender. How do you wish to plead?
Guilty.
Count 30, attempted murder in the first degree of Madeline Wilford. How do you wish to plead?
Guilty.
Count 31, attempted murder in the first degree of Marian Kabachenko. How do you wish to plead?
Guilty.
Count 32, attempted murder in the first degree of Stacy Lapel. How do you wish to plead?
Guilty.
Count 33, attempted murder in the first degree of Anthony Borges. How do you wish to plead?
Guilty.
Count 34, attempted murder in the first degree of Kyle Lehman. How do you wish to plead?
Guilty.
I accept your plea of guilty. I find that you are alert and intelligent, that you had made an informed decision with the advice of counsel. I find that you have made this decision after going over and understanding all of your rights, and that you are knowingly, voluntarily, and intelligently waiving each and every one of the rights that I went over with you today. Is the defense stipulating to a factual basis for purposes of the plea?
Yes, Your Honor, we'll stipulate.
State?
We're prepared to make a factual finding.
Okay.
Your Honor, if this case charging the defendant Nicholas Jacob Cruz with 17 counts of first-degree murder and 17 counts of attempted first-degree murder went to trial, the state would be able to prove beyond an exclusion of every reasonable doubt that the defendant committed each and every one of the counts in the indictment, to wit, 17 counts of first-degree murder and 17 counts of attempted first-degree murder. Some of the evidence that would prove that the defendant is guilty of each and every one of the counts in the indictment, but not exclusive, are school surveillance videos, other surveillance videos, witness testimony, witness identifications, DNA, and the defendant's statements, all of which would be incriminating to the defendant. This is just some of the competent evidence that the state would introduce at trial. The whole of that evidence would establish the following facts, Your Honor. On Wednesday, February the 14th, 2018, the defendant, Nicholas Jacob Cruz, contacted Uber and had a driver drive him to Marjory Stoneman Douglas High School located at 5901 Pine Island Road in Broward County, Florida. The defendant had with him a rifle bag which contained his Smith & Wesson M&P 15 caliber 5.56 rifle, which is an AR-15 type rifle. He had a backpack that contained a tactical vest that had pockets for firearm magazines. The defendant brought with him to Marjory Stoneman Douglas 11 firearm magazines. He directed the driver of Uber to drop him off at Pine Island Road in front of the pedestrian gate located on the northeast side of Marjory Stoneman Douglas High School. The defendant walked through the pedestrian gate and made his way to the 1200 building. The defendant, Nicholas Cruz, had previously attended Marjory Stoneman Douglas High School. He approached the 1200 building, which is located on the northeast corner of the campus. It is the only three-story building on the campus of Marjory Stoneman Douglas High School. He entered the east doors of the 1200 building. The 1200 building has 10 classrooms on each floor, 6 classrooms on the north, on the south, and 4 classrooms on the north. That's on each floor of the 34 building, on the three-story building. Upon entering the east doors of the 1200 building, Nicholas Cruz turned right and walked into the east stairwell of the 1200 building. He then proceeded to take out his rifle from the rifle bag and loaded it with one of the magazines. As the defendant was loading the magazine into his rifle, a student walked into the east stairwell, and the defendant said to him, "You better get out of here. Something bad is about to happen." The defendant then entered the the hallway at approximately 2:21:33, and he fired his rifle at 4 students who were in the hallway. 3 of the students were in front of classroom 1215 on the south side of the hallway. Gina Montalto was sitting outside the classroom of 1215 working on her computer. Martin Duque Aquillano and Luke Hoyer were standing next to her, knocking on the classroom door to gain entrance. Ashley Baez was further west, walking down the hallway towards the west doors. The defendant fired his rifle at Gina Montalto, Martin Duque Aquillano, and Luke Hoyer. They were all shot. Ashley Baez was shot in the leg, but she managed to run to a classroom 1210 across the hall. Ashley Baez survived her wounds. The defendant then turned and fired into the classroom window door of classroom 1216 on the north side of the hallway. He then knelt down in the hallway, took off his backpack, pulled out his tactical vest, put the vest on, loaded another magazine, and he crossed the hallway to the south side of the hallway once again to classroom 1215 and 1214, which are both adjoining classrooms. He again fired into Gina Montalto, Martin Duque Aquillano, and Luke Hoyer. Gina Montalto, 14 years old, who was sitting in the hallway in front of classroom 1215, was shot 4 times and died of her wounds. Martin Duque Aquillano, 14 years old, was shot 8 times, and he died of his wounds. Luke Hoyer, 15 years old, was shot twice, and he died of his wounds. The defendant then began firing through the glass window again into 1214. Then he went across the hall, placed another firearm magazine in his rifle, returned to 1214, and fired once again into classroom 1214. 6 of the students in classroom 1214 were shot. Helena Ramsey, 17 years old, was shot 4 times, and she died of her wounds. Nicholas Dorette, 17 years old, was shot 3 times, and Nicholas died of his wounds. Isabel Checker, Danielle Menescule, Samantha Grady, Samantha Fuentes were wounded, but they survived their wounds. The defendant then walked east in the hallway and once again fired through the classroom window door of classroom 1216. He shot 8 students in classroom 1216. Alex Schachter, 14 years old, was shot twice, and he died of his wounds. Elena Petty, 14 years old, was shot 4 times, and she died of her wounds. Alessa Alfadeth was shot 8 times, and she died of her wounds. William Olson, Justin Colton, Genesis Valentine, Alexander Durrett, and Kashab Magaporium were wounded, but they survived their wounds. The defendant went back across again to 1214, and he fired into 1214 once again. As he was doing that, Coach Christopher Hickson opened the west doors of the first floor hallway and ran in to see what was happening. The defendant fired his rifle at Christopher Hickson, hitting him twice. Christopher Hickson, wounded, crawled across the hallway and hid in one of the alcoves on the north side of the hallway. The defendant then walked up to classroom 1213 on the north side of the first floor hallway and fired through the glass door in the glass in the classroom door. Carmen Shentrup, 16 years old, was shot 3 times, and she died of her wounds. Madeline Wilford was shot multiple times, but she survived. Samantha Mayer was shot multiple times. She survived. And Benjamin Wickander was shot multiple times, but he survived. The defendant then continued west down the first floor hallway, and as he passed Christopher Hickson, who was hiding in the alcove, he fired once again into Christopher Hickson. Coach Hickson was shot 3 times, and he died of his wounds. The defendant then entered the west stairwell, and as he entered the west stairwell, there is a door to the west stairwell. And coming in through the door in the west stairwell, which was Coach Aaron Feiss. As Coach Aaron Feiss opened the door, the defendant fired twice into Coach Feiss, who fell by the west stairwell door. Coach Feiss died of his wounds. The defendant then went up the west stairwell and entered the second floor hallway. As he went down the hallway, he fired into classroom 1231, which was empty, which was on the north side of the hallway. He then crossed the hallway and fired to classroom 1234. It's on the south side of the hallway. That classroom was also empty. He then walked up to the east stairwell, and he walked up the stairs. Due to the percussion from the defendant firing his rifle, the dust from the ceiling tiles caused the fire alarm system to sense smoke, causing the fire alarm to sound. Because the fire alarm was sounding, the students and the teachers were evacuating their classrooms due to the fire alarm sounding. The defendant, upon reaching the third floor, as he exited the stairwell, he fired into Scott Beagle, who was a classroom teacher in 1256. Scott Beagle was shot 4 times, and Scott Beagle died of his wounds. The defendant then fired at another teacher, Stacy Lapel, who was out in the hallway with Scott Beagle. She was wounded, but she survived her wounds. She was a classroom teacher in classroom 1255. As the students and teachers were running back to their classrooms, the defendant placed another magazine into his rifle and proceeded to fire. He shot Meadow Pollock, who was hiding in an alcove of classroom 1249, along with Carol Longren, as they hid in that alcove. The defendant then shot down the hall Anthony Borges multiple times. Anthony Borges survived his wounds. Marian Kabachenko was shot, but he survived his wounds. Kyle Lehman was shot, and he survived his wound. The defendant continued to fire as he moved down the hallway, shooting Meadow Pollock, Carol Longren, Joaquim Oliver Padoy, Peter Wang, and Jamie Guttenberg. The defendant continued further west in the hallway, and as he approached Meadow Pollock and Carol Longren, who were still in the hallway, lying on the floor in the alcove of 1249, fired into them once again. Meadow Pollock, 18 years old, was shot 6 times, and she died of her wounds. Carol Longren, 14 years old, was shot 3 times and died of her wounds. The defendant then approached the alcove of the men's bathroom on the north side of the hall. Lying wounded on the floor in front of the men's bathroom door was Joaquim Oliver Padoy. The defendant once again fired into Joaquim Oliver Padoy. Joaquim Oliver Padoy was 17 years old. He was shot 4 times, and he died of his wounds. The defendant then approached Peter Wang, who was wounded and laying just outside the hallway of the west stairwell. Peter Wang was 14 years old. He was shot 12 times, and he died of his wounds. Jamie Guttenberg, 14 years old, as she was running down the hall, she was able to reach the door on the west side of the hallway. She was shot, and she died of her wounds. The defendant then entered the teacher's lounge, which is on 1240, which is the north side of the hallway. And he fired 5 rounds outside the west window. The window overlooks a courtyard in the parking lot. He then turned and fired out of a south window that looks over a courtyard. He fired 10 shots in total. He then ran out of 1240 and went into the west stairwell, took off his vest that still contained 5 firearm magazines. He laid his gun down, and he ran out of down the stairs and out of the 1200 building on the west side, and he left the 1200 building at 2:27:55 p.m. He then ran and blended in with students who were evacuating the campus due to the fire alarm. As he walked away into a residential neighborhood, he was arrested at 3:49 p.m., approximately 3 miles away from Marjory Stoneman Douglas High School. There are the facts, Your Honor, that we would like on the record as a factual basis for the plea.
Okay. Based upon the stipulation as well as the factual basis presented by the state, I do find there's a factual basis for the plea. And based upon the defendant's guilty plea, I am going to adjudicate him guilty of counts 1 through 34 of the indictment. Also, a matter that was not was placed on the record but not in the defendant's presence, as that I did adjudicate the defendant guilty of all 4 counts of the information in case this was done on Friday. In case number 18-14129, I did on Friday, which was the October 15th, I adjudicated defendant guilty of count 1, attempted aggravated battery on a law enforcement officer, count 2, battery on a law enforcement officer, count 3, depriving an officer means of protection, and count 4 of the information. The defendant was adjudicated guilty. Now that he has been adjudicated guilty, I intend to set the homicide case for trial on the sentencing phase 2 trial. Before I go ahead and discuss that part, is there anything else that either side wishes to add to the record or present at this time?
I believe Mr. Cruz wanted to make a statement to the court and to the victims present in the
Yes.
courtroom.
Okay.
May I take off my mask?
Sure.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me. And I love you, and I know you don't believe me, but I have to live with this every day. And it brings me nightmares, and I can't live with myself sometimes, but I try to push through because I know that's what you guys would want me to do. I hate drugs, and I believe this country would do better if everyone would stop smoking marijuana and doing all these drugs and causing racism and violence out in the streets. I'm sorry, and I can't even watch TV anymore. And I'm trying my best to maintain my composure, and I just want you to know I'm really sorry. And I hope you give me a chance to try to help others. If I believe it's your decision to decide where I go and whether I live or die. Not the jury's. I believe it's your decision. I'm sorry.
Okay. Anything else?
Nothing to say, John.
Judge, at this point, I don't think there's anything stopping the court from sentencing him on the 18-14129 case to 25 years concurrently, Judge. There's nothing to stop the court from doing that.
I'm sorry.
I'd ask the court to impose again, the sentence of count 1 of 15 years Florida State Prison, count 2 consecutive 5 years Florida State Prison, count 3 consecutive 5 years in Florida State Prison, and count 4 is a misdemeanor, Judge. I'd ask the court to sentence him now.
I don't think the victim is here for the purpose of the sentencing for that.
The victim has decided he does not want to be present. He asked me to ask Your Honor to impose the maximum sentence as possible.
I don't believe legally I can impose a consecutive. Counts 1 and 2 are the same.
Well, they're not, Judge. They have different elements, and we do believe that you can sentence him to consecutive sentences. So we would ask for 15 years, which is the maximum on count 1, 5 years consecutive, which is the maximum on count 2, 5 years consecutive to that, which is the maximum on count 3, followed by a year, which is consecutive to that, which is the maximum on count 4.
So even though count 2 is a lesser included of count 1, you believe legally I can impose consecutive sentences on 1 and 2?
It is actually not a lesser included.
Factually, Judge, they're separate offenses.
Yes. Because one is an attempted aggravated battery on a law enforcement officer using an item as a blunt object, whereas the second one is battery on a law enforcement officer, which is based on the punching and hitting.
Okay.
So they are separate offenses.
Are you in agreement that I should impose the sentence at this time?
Yes, Your Honor, we are. We would ask, it's a total of 26 years in Florida State Prison. We would ask that you adjudicate him. You've already found him guilty, and that you impose that sentence.
Sure.
And that is when the defendant was exercising allocution. He said at the very end that he believed that you were in charge of his sentence and not the jury. So,
I'm not sure if he was talking about, I'm not exactly sure who he was talking about. I don't know if he meant you meaning me or you meaning the
but if we can
victims.
clarify so that he does understand that in Florida, it is going to be a jury that determines his sentence as to counts 1 through 17 and not this court. So that we don't have an issue later on appeal or a 3.850 or a 3.851 saying that he misunderstood.
Sure. Mr. Cruz, I'm not sure who you were, I'm not sure if you were talking to me or the victims' families when you said you. But you do understand the state of the law. I went over that with you.
Yes, I do.
And so you know that it's neither me nor the victims' families that are going to be in charge of imposing the death penalty. I don't know if you meant, the way I took it was you meant that they could ask the state to waive it. No, that's not what you meant. Well, why don't you just tell me what you meant?
What I meant was that I believe they should have the right to choose the victims themselves on whether I should take life or death.
So in other words, you're urging the victims to encourage the state to waive it and
No.
sentence you to life.
Judge, may I interject?
Sure.
I think what Mr. Cruz was saying was that ultimately, in his heart, he believes it should be the victims' families that make the decision about life or death. We have, however, explained to Mr. Cruz that it will in fact be the jury that will make that decision after the presentation of evidence of aggravators and mitigators in Phase 2.
Okay.
This, I believe, is just his personal belief.
I understand.
It is in conflict with the law, but he understands the law.
Okay.
Yeah, I
Mr.
understand.
Cruz, is that correct?
Yes.
So if you were the legislature, you would leave it up to the victims to decide what penalty to impose, but you understand that's not the state of the law in Florida.
Yes, I understand that.
You understand it's going to be up to the jury.
I understand that.
Okay.
Thank you, Your Honor.
Sure. Okay, the court having adjudicated defendant guilty, the defendant having waived PSI, the state is indicating that the victim in case number 18 14129 CF10A, which is Sergeant Raymond Beltran, has waived his right to be present before the court today. Is there any legal reason why I should not impose a sentence at this time?
No, ma'am.
On count 1, attempted aggravated battery on a law enforcement officer, I'm going to adjudicate, I have adjudicated you guilty. I'm imposing a period of 15 years, Florida State Prison, with credit for, I believe his credit on the 15th was 1,034 days.
I wrote on the plea form, Judge. I don't have it off.
That would have been Friday, but so,
I'm sorry?
a couple of days.
With credit for 1,345 days time served. Count 2, battery on a law enforcement officer. The defendant has been adjudicated guilty. I'm imposing a sentence of 5 years Florida State Prison to run consecutive to count 1. Count 3, the defendant has been adjudicated of depriving an officer means of protection. I'm going to sentence you to 5 years Florida State Prison to run consecutive to counts 1 and 2. Finally, count 4, the defendant has been adjudicated of attempted use of a self-defense weapon against a law enforcement officer. I'm imposing the maximum sentence of 364 days in the county jail. That is to run consecutive to counts 1, 2, and 3. Each count is to run consecutive to one another. I'm also imposing all mandatory court costs, cost of prosecution, fee for court-appointed counsel, and pursuant to 943-325, the defendant is required to submit to 2 samples of his blood or less intrusive method for purposes of the DNA bank. Sir, you have 30 days to appeal the judgment and sentence of the court. Your failure to file an appeal within 30 days or contest the imposition of the public defender fees would waive your right to contest those fees and or to appeal the sentence and judgment of the court. Do you understand?
I do understand.
You are to be given credit for 1,345 days time served. However, the defendant is to remain in the custody of the Broward County Jail and is not to be remanded to the Department of Corrections until the completion of Phase 2, which is the death penalty trial in the 18-1958 CF-10A. Thank you.
Judge, we would request that as to count 18 through 34, which are not counts that are eligible for the death penalty, that the court impose a sentence of life consecutive to each count at this point, so that the victim's family has some closures as to those counts and understand that Mr. Cruz will not be leaving the Department of Corrections until he dies or if he is in fact sentenced to death on counts 1 through 17.
Your Honor, the victims, all the victims are not here for those counts, and they have a right to be heard, and many of them want to be heard.
Okay.
And I'm in agreement with that, Your Honor. Can we just set it for a separate sentencing hearing on counts 17 through 34 so those victims can in fact be heard?
I mean, my inclination would be to do it at the same time so that we don't have to have everybody come back here more than necessary. State, do you have a position on?
Yeah, I think that your idea is a good one.
Because then we have to have two separate.
No, I understand the court's position. We just wanted, for those families on count 17 through 34, I'm sorry, 18 through 34, have some closure on those counts, and the community can start healing knowing that Mr. Cruz will never leave the Department of Corrections. But I understand the court's position.
I think by you making that statement that's on the record, and hopefully that message will be conveyed, your intention will be conveyed to them. All right, now.
Can we just have a few minutes before we proceed to scheduling?
Absolutely. We'll take how about a 15-minute recess? Does that work?
Yes, thank you.
Okay, thank you. Okay, so for scheduling purposes, we talked about quite a few things. Lawyers, why don't we plan on the 26th at 9 o'clock, reporting for a scheduling conference and status conference? That's the day that the motion to suppress was originally scheduled. And then at that time, you all can tell me which motions are moot, which are agreed upon, which need to be revisited based upon the change in circumstances with regard to the Phase 1 trial.
The defense is agreeable to that.
Okay. And then the only other, I guess I'll call it a housekeeping matter that the state pointed out is that, Mr. Cruz, you are still under oath. I did not go over the score sheet with you based on the fact that the maximum sentence and the minimum sentence, it doesn't really apply, because I told you the minimum is life and the maximum is death. However, in the abundance of caution, the state wants me to let you know, and your lawyers agree, that you score 92.5625 years Florida State Prison at the bottom of the guidelines. However, based upon the mandatory penalties as they pertain to your specific charges, your minimum is life in prison instead of 92.5625 years up to death. And I think that's it. State, are you satisfied?
Yes, Your Honor.
Okay. And I did sign the score sheet and it's in the court file. Oh, you can have it. I already signed. Sure. Thank you. Okay, so you can have a seat. So as far as today is concerned, I believe that's everything, and I will see you all on the 26th, which is Tuesday, at 9 a.m. for a status conference. We will be back in 7750. Judge Williams allowed us to use his courtrooms today because it was supposed to be a trial, so we just kept the plea in here, but we'll be back in 7750 for the pretrial issues.
Because I know there's a lot of interested parties. The court had indicated before about a November beginning the penalty phase. If you could just comment.
Sure. Based upon the information that was provided to me by both the defense and the state, we are going to begin jury selection for the penalty phase on Monday, January 4th. The lawyers are going to utilize we have motions scheduled the last week of October, and the lawyers are going to utilize November and December, which are what I call sort of choppy months because, for example, the courthouse in November is closed on the 11th, the 25th, and the 26th, which makes at least 2 of the 4 weeks very short weeks where we don't have juries, and then the week of December, the month of December, the courthouse is closed the 24th and the 31st. So based on those sort of limited weeks, the lawyers are going to take advantage of those November and December to finish up all of the penalty phase related motions, related depositions, related preparation, and then we are going to be starting again January 4th with jury selection. If you all can please be prepared on the 26th to let me know any preliminary plans that you have as far as jury selection. I think based upon we will be able to utilize this courtroom so we can we can fit more people. However, based upon the limited amount of questioning that the court did in the other trial, it seems like 200 to 250 are the maximum amount of people, even with very limited questioning, that we can get through per day, as opposed to the jury room had like over 500 for us one day for the last trial. I don't think that's necessary because I don't think there's any way we can get through more than, based on my experience with the other trial, even though this is not the same, even if it's very preliminary, I think 200 to 250 per day would be the maximum. Does anyone disagree with that number?
No.
Okay. So when I have them start issuing the juror summons, I'm going to have them keep that in mind, because I hate to have, 300 extra people waiting around all day to be questioned when there's absolutely no way we can get to that many per day. So we'll try to have at least 200 per day for pre-jury selection to go through. And we'll start that on January 4th. Other than that, I'll see you all on the 26th. Yes.
Are we deferring what constitutes pre-selection until another date?
Yes, that's what I wanted to discuss in part on the 26th. And if you all, because you all were going to have,
We have come to agreement on some of those issues.
that would be
and
great.
we'll revisit them
And
on
I know it's
Friday.
not going to be the same as the other trial, because obviously there's other issues that need to be addressed. But I was saying, just taking the other trial just as an example, with my very limited, announcement of the charges and so on and so forth, just to get that many bodies in, even assuming we can take 50-something at a time, I don't know how we can get through more than 4 groups in a day. I think Mr. Ehrman would probably agree with that, okay?
There's just some other issues that
Sure.
we may be able to
No,
move
absolutely,
forward.
absolutely. So we'll discuss all of that on the 26th. I'll see you all at 9, and we're in recess.
Thank you.
Thank you.